Let's get to the meat of the matter. You got this trust set up. How do you actually get assets into the trust? After all, I mean, if the purpose of this trust is to give you asset protection, you've got to have assets inside the trust. So, how do we get those assets in there? Well, let's go back to the trust structure again, the trust dynamic. What we have is the grantor, the person who creates the trust. Then we have trustees, they're the ones who manage the trust assets. And then we have the beneficiary, the one who gets the benefit of the use of the trust assets. So these are the three different parties to a trust. First, easiest, simplest way to get assets into the trust is the way that this has happened for generations. What we do is have the grantor, the one who creates the trust, they just contribute assets into the trust. So, example, the grantor, let's say it's your parents, they want to set up a trust for your benefit. They might put 5,000, 10,000, 300,000, $3 million into the trust. And now we have the situation where it is the grantor themselves putting the assets into the trust. And we have no issues because that's the typical traditional design of a trust, is having the grantor put the assets into the trust. Now, once the grantor has put the assets into the trust, at that point in time, we can do some neat stuff and we can have the trust create a business. That business can be a corporation, a C corporation, an S corporation, an LLC, an LP. It just doesn't matter. Trusts are allowed to own businesses. So now we have the grantor put assets into the trust, and now we have the trust create a new business. And this brings up a really interesting dynamic in that the trust beneficiary, probably you, they can now work for that business. And as that business makes money, the trust, gosh, it can pay a salary to you. Uh, Key point here, guys. This isn't a wink, wink, nod, nod. This is a valid strategy, a valid, legitimate strategy. I hate to use the word legitimate, but some people try to stretch things a little bit too far. If you empty the waste paper baskets for this business, you can't have the business pay you $500,000 a year. That's just not going to work, guys. That is not going to work. It has to be a reasonable salary that is commensurate with the work that you do. So, once again, it's got to be a reasonable salary. Now, if you are providing services to that business, and chances are that's going to probably help the business expand and grow. It's the typical situation as if you worked for IBM. If you work for IBM or a large corporation or any other business, typically you are not paid what you make for that company. Example, you're working for IBM, you get paid $50,000 a year. IBM would not hire you if you're only bringing $40,000 of value to that company. They're probably looking for you to provide value of 100,000, 150,000, etc. So if the trust creates a business and you work for that business and you provide value, you don't have to be paid all the value. You're going to be paid a reasonable salary. So, I don't know, if you're helping this business by identifying real estate and helping the business flip that real estate, let's say the business makes $100,000 a year. You could be paid, I don't know, let's just say $30,000, $40,000 a year in salary, and the rest of the profit stays within the business, which is owned by the trust, which is now protected. Now, let's say that the business wanted to help you out some more. Well, at that point, they can start paying for medical benefits for you. So it can make medical payments on behalf of you, and chances are that's not going to be taxable income to you. Or it can start making retirement contributions to a 401k on your behalf, and chances are, once again, that's not going to be taxable to you. So, simple way to move assets into the trust, the simple, easiest way that, has been done since the very beginning of trust. The grantor, the party who creates the trust, moves the assets into the trust. Once the assets are inside the trust, they could be invested inside a business, and that business could now employ you, the beneficiary, and you can now start providing services to the business to start expanding its profit. Now, some of you can say, okay, that's fine, Tim, but I already have some assets myself that I want to start moving into this trust as well. Can I do that? And the answer is sure they can, but it has to be done right. So whenever I use those weasel words, so long as it's done right, what do I mean exactly? Well, let me show you what I mean by showing you the wrong way to do things. And by showing you the wrong way to do things, if you don't go that route, you're probably going to be safe. And so let's go through the first steps here. Number one, basic rule of trust. Once again, a basic rule of trust. If the grantor and the beneficiary are the same person, typically there is no asset protection. Now, there are some states that are allowing trust to be established where the grantor and the beneficiary are the same party, but in the vast majority of the states, the grantor and the beneficiary cannot be the same party. Now, why am I bringing this up? Why am I emphasizing this? Well, if you just start moving assets willy-nilly into the trust and you don't receive anything in return, you are now effectively becoming a grantor of that trust. And since now, at this point, you're both the grantor and the beneficiary, you're losing asset protection. So, whenever you're moving assets into the trust, you need to make sure that there's no gifts to the trust and all the transfers are made for a reasonably equivalent value. And let's kind of hit upon that last phrase. Reasonably equivalent value. Once again, this is not wink, wink, nod, nod time. We have to do things correctly. So that's the first issue you got to look at. Other area we got to be aware of is the fraudulent transfer rules. And fraudulent transfer rules basically say if you make a transfer of property and your intent in transferring that property was to defraud, hinder, or delay your creditors, then your creditor can not only just go after you, but now they can go after the party that you transferred the assets to. So in our situation, not only can your creditors go after you, but they could go after the trust as well. So pretty much, if you do a fraudulent transfer, that's probably the best thing that could have happened to the creditor, because now they can go after you and the trust as well. They get to double down on who they can go after. We see this a lot with people making transfers of assets to their spouse, to their kids, to their parents, to whoever, and you always got to shake your head because those people messed up so bad. Before, the creditor could only go after the individual who owed the creditor, but now by doing that fraudulent transfer, they have now opened up their friends and family to attack as well. So we want to avoid fraudulent transfers and we want to avoid claims of fraudulent transfers. Now, this wording here says a transfer of property made by a debtor with the intent to defraud, hinder, or delay his or her creditors. A challenge here is they really don't have to show that you had the black and white intent to defraud the creditors. What they can normally do is walk through a number of what they call badges of fraud. And if you meet these badges of fraud, then the creditor can go to the court and say, Your Honor, the debtor moved these assets, they meet these badges of fraud, so let's pull back the assets and say it was a fraudulent transfer. And some of the most, common, egregious badges of fraud here are, number one, a transfer without receiving reasonably equivalent value. I cannot overemphasize the importance of any time you make a transfer, you have to receive reasonably equivalent value. The way I think of it, it's kind of like a scale, the scales of justice, if you will. If you make a transfer over to the trust and you don't receive reasonably equivalent value, chances are that transfer is going to be disregarded. It's going to be considered a fraudulent conveyance, or it's going to put you into grantor status that loses the asset protection. So anytime you make a transfer, you want to receive reasonably equivalent value on that transfer. Other big one. If you make a transfer over to the trust and you are now insolvent after the transfer, that's probably going to be considered a fraudulent transfer as well. Now, what do I mean by insolvent? Well, a couple different tests for it. Number one is, once you make the transfer over to the trust, what's your balance sheet look like? What do your assets look like in comparison to your liabilities? If your assets are now less than your liabilities, you're probably going to be considered insolvent. Another way they look at insolvency is, can you make your payments on an ongoing basis? Are you paying your bills on an ongoing basis? If you move all your cash into the trust, and now the trust just gives you a promissory note in return for that cash, if that promissory note isn't paying you enough for you to make your monthly payments, your annual payments, whatever, then you're going to be considered insolvent, and that also is going to be considered a fraudulent transfer. So what we're trying to avoid here are those things that can wipe out the protected status of your trust. And another one of those, by the way, and I'm bringing this up because there was just a brand new IRS tax court case where the IRS, and they love to do this, they love to claim that the trust is your alter ego or nominee. And the factors they used in this particular case, which I thought I'd bring up to you guys, is number one, no consideration or inadequate consideration paid by the trust. Now, what the heck do they mean by consideration? Consideration in this context is pretty much a fancy legal phrase that says you did not receive a reasonably equivalent value. So, in order to avoid this alter ego or nominee charge, make sure you receive assets in return of a reasonably equivalent value. Number two, property is placed in the name of the nominee, in this case the trust, in anticipation of a suit or liabilities. You know, if you get a notice from the IRS that you owe them $50 million, and let's say you get that notice on April 1st, and then April 2nd, you move the assets into the trust, chances are the IRS is going to come in and say, oop, they're using the trust as their nominee, or they're using that as their alter ego. And more than likely, the judge is going to agree with them. Once again, I can't overemphasize this. The time to do your planning with your trust is before the liability occurs. It's kind of like having fire insurance. If you pull into your driveway and you see your house is in flames, that's not the time to pick up your cell phone and call State Farm and say, hey, State Farm, I want to take out that fire insurance policy. The time to start doing this asset protection planning is before any liability starts accruing. If you wait till the liability has accrued, if you wait till the judgment is rendered against you, chances are you're probably not going to be able to do much with your asset protection planning. Other things they look at for this alter ego or nominee status. A close relationship between the transferor or the nominee exists. Well, in this case, that's going to be a true one. There is going to be a close relationship between you and your trust. So what we want to do is have a preponderance of the factors on our side, but some are going to be against us. In particular, having a close relationship between you and the trust. Next one is transfers were not recorded. I can't overemphasize how important it is to have a paper trail as you're moving all this stuff over to the trust. If you're going to be lending something to the trust, you're going to be lending money to it, making a loan, make sure you got a promissory note. Make sure it's a valid promissory note with great terms on that promissory note. And whenever I say great terms, I don't mean a one-sided promissory note. It needs to be a commercially reasonable promissory note. Other factor they look at. The transferor, you, retained possession of the property. If you say that you're going to transfer a car to the trust, and actually I don't even want to go through that. Just don't transfer a car to the trust. Just that simple, guys. Don't transfer your cars to the trust. Makes no sense to begin with. Number 6 is kind of the same thing. The transfer continued to enjoy the benefits of the transferred property. Overall statement to make on this alter ego or nominee status. If you want others to respect the form of the transaction, you have to respect the form of the transaction as well. If the trust is now the owner of the assets, please don't put those assets on your personal financial statement. I can't tell you how many times people, on one hand, say they have assets worth $200,000 that are owned by the trust and thus they're protected. And then on the other hand, whenever they go to get a loan, they claim those assets as their personal assets. Guys, they're not your personal assets anymore. They are now assets of the trust. And let's start walking through some examples of this stuff. So, number 1, we've got the grantor over here. We got the trustee. Now we have the beneficiary. The beneficiary gifts assets to the trust. What do you guys think? Is this arrangement going to provide for any asset protection? Trust loses its asset protection. Why does the trust lose its asset protection? Well, number 1, the beneficiary is now the grantor. If they just gift assets into the trust, now the beneficiary is going to be considered a grantor. And once again, in most states, if you are both the grantor and a beneficiary, you lose asset protection. Number 2, we've probably got a fraudulent transfer here. If you had any creditors lying out in the wings and you start moving assets and you don't receive reasonably equivalent value back in return, we've got a fraudulent conveyance. We've got a fraudulent transfer. And number 3, potential nominee issues. What was that first factor? If you move assets without receiving any consideration. A gift is almost the definition of moving assets without receiving any consideration. So, if we establish this trust for your benefit, you're the beneficiary and your parents are the grantors, the ones who created the trust, you cannot just willy-nilly place assets into the trust. You can't just gift assets to the trust. Well, let's take it to the next level then. Let's say that I've got something that's worth about $100,000 and I sell it to the trust for $30,000. Now, some of you, this is just blatantly obvious. You're rolling your eyes. You're thinking, stupid example, Tim. Guys, I cannot tell you how many times I see this on pretty much a daily basis. Somebody saying, well, I think I could sell that for $100,000, but could I get away with saying it's not worth anything or it's only worth $15? Everything you do has to be on a commercially reasonable basis. You can't sell an asset to the trust for that's worth, if the asset's worth $100,000 and you only get $30,000 back, we're not going to have asset protection. Why? Number 1, they're probably going to consider you a grantor of the trust for up to that $70,000 portion. So now grantor equals beneficiary equals loss of asset protection. Number 2, we've got a potentially fraudulent transfer of $70,000. And number 3, we got the nominee issues where we made transfers for inadequate amounts of consideration. So any transaction that you engage in with your trust has to be done on a commercially reasonable basis. Next one. Beneficiary sells assets worth $100,000 to the trust for an unsecured promissory note at 1% interest. And let's just say the promissory note's for $100,000 also. Well, we're getting on the right path, but we're not quite there. And what are the problems here? Number 1, unsecured. Whenever we look at if there is a reasonably equivalent value given in return for the assets, we're looking at it through the lens, through the eyes, if you will, of the creditor. So if the promissory note that is given back in return for those assets is just really a junk promissory note, well, in the eyes of the creditors, it's going to have little value whatsoever. And so they're going to consider that a fraudulent conveyance. The promissory note has to have teeth in it. I typically draft the promissory notes to say that the trustee, by signing this promissory note, agrees that they will not make any distributions out of the trust at any time that the net present value of the trust assets are less than the value of the promissory note. So the promissory note needs to have some real teeth in it for it to be respected by the courts. Other thing too, we've got to be dealing with real world numbers. We can't go in there and say we're going to make a loan over to the trust or we're going to sell an asset to the trust and the promissory note only is 1% annual interest. How many banks would go out and loan you money right now for 5 years, 10 years, 30 years at 1% annual interest? Now, I know some of you are right now saying, oh, that's what CDs are paying. The CDs are only paying 1 or 2%. Why can't I do the same thing? Guys, that is the banks ripping you off, not you ripping off the banks. Banks rip us off all the time. Accept it, get used to it. We've got to have the terms of the promissory note, commercially reasonable terms. What interest rate would a bank charge you right now for a promissory note of the same equivalent time period as the promissory note between you and the trust? So if you sold assets worth $100,000 to the trust for an unsecured promissory note at 1% interest, would that give you asset protection? No asset protection. The trust will lose asset protection. Future creditors would probably argue the promissory note's a fraud and shouldn't be respected. Finally here, the beneficiary sells assets worth $100,000 to the trust for a secured promissory note at a reasonable interest rate. Well, what do you guys think? Yeah, sure. That's going to be respected. And that's just kind of the moral of any transaction that you, the beneficiary, might engage in with the trust. so long it is done on a commercially reasonable basis and you document it, you have a nice paper trail, it will probably be respected. And this is a way on how you can move assets into this trust and have those assets build up in the future and have them build up on a protected basis.